All right. Hey guys, welcome to the Atlanta Landlord Luncheon. We meet every third Monday of each month, and our goal is to bring you monthly education, market updates, and networking events for buy and hold real estate investors so that you can build long-term wealth. You're welcome to follow us on Facebook, LinkedIn, YouTube. Just search for the Atlanta Landlord Luncheon. And this is a new format we're doing where we're live streaming as well as meeting in person at the Hobnob Tavern in Dunwoody. I do want to bring up, we have some upcoming speakers. So next month we're going to have in December 16th, Ted Steinkamp from Advanda IRA talking about how you can use your retirement funds to invest in real estate in either tax deferred or tax free on those investments. So that'll be an interesting talk to tune into next month. But just want to introduce myself first. My name is Matt Martin. I'm here at PMI Georgia, and this is Chris Littleton, one of our owners here.
Hi, I'm Chris Littleton with PMI Georgia. I'm also a real estate investor. Been doing this for about 21 years. We'd be happy to help you out with your buy and hold needs. Also, if you have any questions about real estate in general, we'll be more than happy to help you here at PMI Georgia. And we also have an acquisition team to help you find properties as well. So it's a great market. I love buy and hold. Like I've always said, real estate investing it's a marathon, not a sprint. It's a long-term journey to wealth, and it helps create a lot of wealth out there for individuals that choose the path of real estate investing.
That's right. So here at PMI, we offer investors simple, straightforward property management with Southern hospitality. We manage over 500 doors throughout Metro Atlanta, and we cover a pretty wide area. So we go as far north as Gainesville and Cumming, and as far south as Macon and Warner Robins. So if you are starting out with your first investment or trying to grow a portfolio, we pretty much got you covered. So I'd love to offer you a free rental analysis if you have a property that's coming up vacant or you're thinking about putting on the market. We'd love to talk with you about managing that property for you. But next, I'm going to hand it over to Chip Cagle, who's over at Hobnob Tavern in Dunwoody.
Hey, can you hear me now?
You're
Hello.
on.
Yes,
All right,
we
so
hear you.
we're at Hobnob Tavern in Dunwoody. Please join us next month, December 15th. So I'm with Longhorn Investments. And Longhorn does fix and flip loans and new construction loans for your real estate investing needs. On the fix and flip side, we can do 100% of your purchase and rehab, as long as that's less than 70% of the appraised ARV. We can even go up to 75% if you're thinking about keeping it as a rental property. It doesn't mean you have to keep it as a rental property. It just lets us know that if you did, we'd get paid off. So I'd love to talk to you about that. Give me a call, 404-216-5599. Then we've got the new construction loan. It's 90% of the lot purchase and 90% of the construction. So you got a 10% down payment. However, if you already own the lot, you can use what you paid for the lot towards the down payment on the construction cost. So you could get 100% of your construction budget. And the new construction is as used interest, so you wouldn't pay interest on the money until you drew it. And so again, phone number 404-216-5599. So I've got somebody here that I want to bring up and let her introduce herself. She's I work with her in the Atlanta area quite a bit, so I appreciate her being here. Arrow Taylor.
Hey everybody, my name is Arrow Taylor. I own Under the Willow Home Staging. We offer several services for investors. When you have a fix and flip, we rent by the month. Furniture that we have, we can do STR purchases for you and install them. We can do design work for you. If you're needing help with that, picking selections for any of the projects. We're also now a prop house for the production industry, so we can handle that as well if you know anybody in that era or area. We've got an 8,000 square foot warehouse. We've got 7 stagers who work with me, and 4 warehouse technicians. I own a 20-foot box truck, and we're ready to go wherever you need us to go. We do a lot of Metro Atlanta, but we have gone beyond that as well. So give us a call at 678-910-9802, or you can email me at arow@utwhomestaging.com. Thanks.
All right. Thank you, Chip. Okay, I'm going to add to the stage Amanda Riedling, who is our guest speaker today. Oh, let's see if I can get our pic. There we go. Who's our guest speaker for today. I'm super excited to have her on. One of the most common questions we get from especially new investors is how they should hold title. A lot of times they're renting out a property for the first time. Maybe this was a house they lived in, so they hold it in their name because that's how they got the financing for it. There's also a lot of talk about LLCs or trusts or things like that. And Amanda is going to share about some of the estate planning challenges for investors, how to avoid probate, but anyway, so Amanda is an attorney in Cobb County. She's the owner and partner of Georgia Wills Trust and Probate Firm in Marietta. She's a graduate of UGA and Georgia School of Law, so go Dogs.
Go Dogs.
Yep, and she is very, very active in the local bar association there. That's the legal association for for some of you guys. But she's going to be, I think she said, the president of the Cobb Bar Association next year.
Well, congratulations.
Yeah, very exciting. So Amanda, I'm going to unmute you and hand it over to you. Thank you for being with us today.
Thank you so much for inviting me. I've told Matt that I will talk about this stuff to anyone who will listen. So I appreciate the platform. And one thing that I really love to do is educate. So that's what I do with my clients every day. And I'm happy to join you guys and hopefully teach y'all something today too. So I titled this presentation, The Do's and Don'ts for Titling Real Estate, Tips for Avoiding Probate and Passing Real Estate to Beneficiaries. So as you probably already put together, so we do wills, trusts, and probate work. That's all I do all day, every day. The planning side, helping people set up a great plan for passing assets on to their loved ones in a responsible way, not only for what their wishes are, but also what's responsible for their actual beneficiaries. And what's best for them too. And then we also help on the probate side. So if it comes time to implement a trust or a will, we can be there to help folks navigate the probate court or make sure they're following the trust rules and have all the help they need for that too. So the first thing I want to start with, and a lot of people know, they've heard the word probate before, and it's like the assets go through probate, but what does that mean? Usually, unless you've been through it with a loved one, or you've done it for a parent or a grandparent or a friend, it's kind of this blurry thing out there that you're not really sure what it is. So what probate is if you own property either just in your name or in a few other ways that we'll talk about, even if you have a good solid will, your will cannot be implemented until after your loved ones have filed it with the probate court and have gotten approval from the judge and your executor has actually been appointed by the court. So that's one myth out there. A lot of people think that, oh, well, I've got a will. When I pass away, my executor can just take that will and go do things and go get into my accounts and go sell my real estate and talk to my lenders and all that. And that's not the case. So assets that pass under your will are going to require that process of filing it with the probate court. And if any of you have had to deal with that recently, you understand how time consuming and expensive that can be, especially if you have any minor heirs. One thing that people learn about probate is that even if you've left someone out of a will, or even if you have not included them as a beneficiary, if they are what's called your heirs, which is a legal term for your next closest relative, so to speak, whoever would be your next closest relative, whether you like them or not, whether you're estranged or not, whether they're inheriting from you or not, they're still involved in that process, because those are the people that would inherit from you if you did not have a will. So it could be an estranged child. It could be lots of folks that you probably maybe don't want involved in that process. But even if you've got a good solid will, your heirs still have to get legal notice. And what that means is the court serves them with a copy, and then they get 30 days to object if they want to try to cause trouble. So probate kind of invites a fight if that's something that is a possibility among your loved ones and among your heirs. So I have lots of clients who will come in and say, okay, well, how many children do you have and all that? And sometimes, actually, one time I remember I got all the way almost to the signing table, and this guy said, oh, well, I actually have 2 children, but I haven't talked to them in 30 years, so they don't count. And I'm like, whoa, wait a minute. Yes, they do. We have to put them in here. We have to remind the world that you know about them so that they can't come and fight your will. So even if you are estranged, you still have to deal with those heirs. So again, probate, it takes time, it costs money. Right now, even with a good will, you're looking at least a couple of weeks to a month. If you don't have a will, you're looking at more than a few months in a good jurisdiction. Like Cobb is a pretty good jurisdiction. I have some counties right now that we work in that take a lot longer. I've got a few that take 6 months or more before anyone can ever even get access to do anything with the real estate. And guess what? The mortgages, if there is a mortgage, still have to be paid by somebody, but the lenders won't talk to you. You just have to keep sending payment, and it can cause a lot of stress and confusion in your family. So the good news is there are lots of other ways that you can title real estate so that you can make sure that your loved ones inherit it, but maybe exclude some of those folks that you aren't wanting to include. So there's 5 different ways that I want to talk about. My favorite way, and the one that I think gives you and your clients the most bells and whistles, so to speak, as far as planning for contingencies. And we don't have a crystal ball. We don't know in what order people will pass away, right? A lot of folks assume, okay, well, I'm the parent, my child will outlive me, so my child will get it, and then my grandchildren, all that. But we don't know in what order people are going to pass away. And so that's where revocable living trusts can come in. I would talk about LLCs and the pros and cons to that. Not all real estate that you own, I advise putting in an LLC, but certainly income producing property. Joint ownership, of course, is one way. I want to get into the nuance of that, though. There's actually 2 ways to own joint real estate in Georgia, and you may not have the one that you think you have. I see it all the time in my probate practice where spouses own property jointly, and so they never got a will. One spouse passes away, and I have to break the news to the other spouse, hey, you didn't automatically inherit this. That other half of the house passed under that person's estate, and you now own your house with your 2-year-old, or you now own your house with your stepchildren. So we'll go through that. Beneficiary deeds, these are brand new to Georgia. There's going to be changes to this law. I'll go through what it says now. I'm not doing this right now, except in a very, very small scenario. So we'll talk about that. And then life estate deeds as well. So we'll go through what that is. So revocable living trust, I'm actually going to come back and do this one last. I think it'll be helpful to hear about the others and sort of the downsides to the others, and then come back to revocable living trust, because it really solves all the downsides to all the others. So we're going to come back to that. And I'm sorry, some of the text is coming off the top there. Okay, so let's talk about limited liability companies. Typically, this is what you or what I advise you to put your real estate in that is income producing or could potentially cause you liability. Meaning, you're renting a property out, there's some stairs that maybe need some repair and you haven't gotten around to it. Someone slips and falls on the stairs, breaks their leg, and then they sue you because it was your property. Yes, this is never a replacement for insurance. Make sure you always have really good insurance. I also recommend umbrella policies on top of your regular insurance for your property. So you typically, well, not typically, but if you're going to put your real estate in a limited liability company, what that does for you is it moves it out of your name. You as a person no longer own it, and this business owns it. So the benefit there is when you own property in a limited liability company, if someone gets injured in that property and that property is deeded into that LLC and they get injured, the containment of that liability is going to be only within that LLC. So what that means is if you've got your rental property in the LLC, someone gets injured, that person that gets injured can only claim assets for their injury that are in that business. So that's where good insurance is going to come in. And then they could potentially go after the value of the property, yes. But what they can't do, as long as you meet certain requirements, is they cannot do what in law school we learn as piercing the corporate veil. They cannot go through that LLC to come after your other personal assets. So it contains that liability in a smaller segment of something you own. That way they can't come after your home, your retirement, your other investments, that kind of thing. So a lot of people and a lot of clients that I know will own each property that they own in a separate LLC to sort of get the combination of those, or not combination, but the smaller bubbles of liability protection. Now, with it, however, comes a few things. If you have a loan on the property, you cannot put it in an LLC without your lender's permission because it is an actual transfer of ownership. So it's coming out of your name into that LLC. So it could trigger an acceleration clause. So never, 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 never do this without permission from your lender. My law partner and I, we bought the building that we have our law firm in, and we did it there at the table. So the lender knew that's what we were doing right away. We still had to be guarantors on the loan, of course. So if we default on the loan, the lender can come after our personal assets. But we were able to go ahead and get that put into an LLC the day that we bought it. So at least the liability protection is there if anyone sues us for any injury on the property, for example. You do have to treat it like a business. So it is a business. You have to treat it like a business. So that means you got to have a business bank account. You've got to do tax returns. You cannot treat it like your personal piggy bank. You can only spend business money on business expenses. The money you pay yourself out of that is then income. You want to work with your accountant about the best way to claim that on your taxes, whether you do it through S Corp status, S-CORP, S Corp status. The LLC code sometimes requires yearly meetings and all that stuff. So just be very careful when you're doing this, especially if you do choose to do S Corp status. And I say that very slowly because I realized some clients thought I was saying escort. And so I've learned over time to say S-Corp, just so people aren't confused. But be very careful with those, because if you're married and you then want to avoid probate for the company, meaning you don't want to have your family go through that probate process, you don't want them to have to deal with the probate court and all that bureaucracy and all the delay and the cost, you still have to point that limited liability company to a revocable trust, or depending on how valuable all of your investments are, you may need to do some more sophisticated tax planning with irrevocable trust. We're not going into that today, but at least as a minimum to avoid probate, you can assign the limited liability company to a revocable living trust, which I'll get to towards the end. But if you elect S Corp status, then you may not be able to put it into a joint trust, so you may need a separate trust for that LLC. So there's sort of layers of planning that I will go through with clients that have these types of LLCs. Okay. Also, other things, it requires filings with the Secretary of State, and you got to do that every year, and all the fun things with a business. Special considerations for business owners that I see people make mistakes in my estate planning practice is loved ones not being able to find the bylaws or the agreements for the business. So those bylaws and operating agreements can have in them clauses about who can step in and run your company if you are incapacitated, meaning you're in a coma in the hospital, you're hit by a bus and you're temporarily out of it, or permanently incapacitated. But also who's going to step in and take care of you, your clients, your properties, if you pass away or you need to be away. So the operating agreement can cover that. Another thing, as far as estate planning and businesses go, is you want to think about whether it's appropriate to have another officer or employee who has access to the bank accounts and can still sign checks in the event that you're unexpectedly incapacitated or unexpectedly pass away. Okay. Otherwise, what happens is your estate would have to be probated, or a court order would have to be sought if you were incapacitated, so that someone could get access to run that. And that's expensive and time consuming. Bills could go unpaid in the meantime. Employees could go unpaid in the meantime. So planning ahead for that is something that you want to make sure you do as well. Insurance. So we're kind of getting a little outside of the main topic, but I always want people to think about buy-sell agreements. If there's a business partner that can take over for you, or you want to take over for you, key man life insurance policies, so that the business is protected in the event that a main business owner or main employee who generates a lot of business for you is unexpectedly incapacitated or deceased. So I know these are not fun things to think about on a Monday at lunch, but they are important. Okay, so joint ownership. I sort of touched on this already, but joint ownership is one of the most common ways to avoid probate in the event of your death. So most spouses, for example, will buy their home jointly, or they'll buy rental properties jointly. So joint ownership, of course, is where more than one person is on the title and owns the property. So as I mentioned before, there are actually two ways to own real estate jointly in Georgia. One is where what most people think happens, kind of like with a joint bank account. If one passes, the other automatically is the owner of that account, right? Well, with real estate, that's one way, but there's also another way. So one way is what's called tenants in common. And so you don't have to remember the term. It's real easy to determine on the face of the deed which kind you have. But if you own property jointly, and there's two people on the deed or more, it could be more than two. If it says, oh, sorry, let me go back. You see the second point here where it says joint with rights of survivorship. If your deed says that, then you don't have tenants in common. So I know if it says rights of survivorship, that's what you have. If it doesn't say that, then you automatically have tenants in common. So joint with rights of survivorship is the kind that most people think they have, but really, unless you look at the deed, you don't know. Joint with rights of survivorship is where if one person passes, the other automatically owns that property, or that person share that property without the need for probate. It does not pass under a will. So let's say you wanted someone different to inherit that property, but you own it with rights of survivorship with someone. It's never going to pass under your will to get to that person. So it's important to know what kind you have and make sure you have the kind that you want so that your wishes are carried out. Tenants in common is every other kind of deed. And what that means is whatever portion of that property that you own passes under your estate through the probate court. So if you have a will, it passes under whoever inherits from you under your will. but your will has to be probated first. So if you have tenants in common, it still requires probate. Okay. So you're not only are you not avoiding probate, but if it's your intention that the other joint owner inherit that property from you, that's probably not going to happen. Okay. You're going to end up passing that property to someone else that you may not have intended. And so you always want to look. I think a lot of closing attorneys and all that now are keen on asking when there's two people buying a property, which kind do you want, or they're automatically doing the rights of survivorship. But for blended families, for example, you probably, well, not probably, you may not want the automatic rights of survivorship. Maybe each spouse has children of their own that they want their half of the property to go to. And so it's just important to know what kind you have. Okay. One of the biggest myths I see when my clients come in for estate planning is they assume that if they have a spouse, that their spouse automatically inherits everything from them. So why do they need a will? And that is absolutely not the case. If you have a spouse and you do not have children, neither spouse has children, not from a previous relationship, not in the history of their lives, not any that have passed away, anything like that. That's the only scenario where the spouse inherits automatically. If either spouse has children, then it ends up going to spouse and children. And so in my probate practice, I've unfortunately had lots of cases where it was a young family, spouse passed away, they have minor children, and they did not have the kind of deed they thought they had. And now they end up, like I said earlier, owning their house with their 2-year-old because that half of the house passed under probate to spouse and children. And guess what? It's not fully yours. You can't sell it. You can't refinance. You can't do anything. And there's special considerations for minors as well. So you definitely want to avoid that. So lesson here is if you use joint ownership, make sure that you have the kind that you want. Now, a word of caution here. I get lots of clients who one parent has passed away, or maybe it's a grandparent, and they'll bring the parent in and say, well, mom wants to add me to the deed so that when she passes away, I inherit it automatically outside of probate. So yes, that would work that way. However, it is so against the client's interest that I will actually refuse to do it in 99% of cases, because not only are they, if you add someone to the deed to your home, you are giving away that portion of the home. You no longer own it completely. You lose control over being able to sell it, refinance it, do all the things. Also, you've now added another person to your deed that maybe they're driving around in their car and they cause an accident. Now they're getting sued and their personal assets can be brought into that lawsuit. Well, guess what? If they own half of your house, that's going into the lawsuit too. What if they're married and now they're getting a divorce? That's an asset that they own that could potentially be brought into that divorce. One of the more common reasons folks don't like to do it is if you add a new owner to your house, you lose that step up in basis for capital gains tax purposes as well. If you pass away and your property passes on either through a revocable trust or joint ownership, or not joint ownership, but through your will or through a revocable trust, the laws are today that your beneficiaries get a complete step up in basis, meaning the capital gains calculation is not going to start way back when the house was originally purchased, but it starts over the day that person passed away. So the capital gains is only going to be calculated on the gain after death. So if you add a child or grandchild or someone to your deed, you could be ending up with a big tax bill. Okay. So beneficiary deeds. This is brand new and it needs some work, guys. So there are very few states that do this. I'm shocked that Georgia ended up being one of them, but you can now add a beneficiary to the deed to your house. The potential for fraud here is just scary to me as a probate lawyer, but I'll kind of go through what it allows, and honestly, I don't recommend it in most cases right now. So even if you have a beneficiary deed, meaning you add a clause to your deed that says, if I pass away, this person will inherit this property outside of probate. Sounds great. in theory. But you still want to always have a good solid will no matter what, because what if your beneficiary dies before you? This gives you zero ability to plan for those contingencies. Okay. Another issue with the law is the beneficiary is not required to be notified that they have become the beneficiary of the deed. And the reason for that, I think, is they wanted people to be able to change it without having to have that awkward conversation with the beneficiary of, hey, I had you on there, but I'm taking you off. Sorry. Um, the owner of the house can change the beneficiary whenever they want. So that was good. But if you pass away or the owner passes away and the beneficiary doesn't know that they're the beneficiary, what happens is they lose it. They have 9 months to claim it. And to claim it, they have to actually file an affidavit with the deed office. So this is the part that really makes it to where we're not advising this until this gets cleaned up a little bit. So let's say you have a family where the siblings don't get along. One of the parents has passed away. The other parent adds a beneficiary to the deed, and it's one of the siblings. Let's just assume there are 2 siblings. The siblings hate each other, and they put one of the siblings on there. Well, let's say that the other sibling notices, but doesn't tell the other sibling, and the other sibling isn't sophisticated enough or doesn't know to go look at the deed and has no reason to think that they would be on the deed. Well, the other sibling could just wait the 9 months and then it goes away if they haven't claimed it. And so there's that space of time. That 9 months is the real big problem. So if the beneficiary doesn't claim it within 9 months, it passes under the person's estate, which again is why you want to make sure you still have a good solid will. It's not going to be in place of having that good solid will. The other confusion this is causing is who's going to pay the bills in that 9 months? Because even if there's a will, let's say you have a will that says everything goes equally to my kids, but you have a deed that says this one child is my beneficiary on this property. Who's going to pay the bills in that 9 months? Ideally, the beneficiary knows and they can claim it right away and it's theirs and they can pay the bills, but properties get foreclosed on in a lot less time than 9 months. So what if someone pays the mortgage and the taxes and the utilities and all that, and then this beneficiary comes and claims it in month 7 or 8? Well, now who's going to pay that person back? Do they have to pay that person back? Well, technically they hadn't claimed it yet. There's just so much that's going to be up in the air for those cases where the beneficiary doesn't claim it right away. Also, people may think, oh, well, I'm the beneficiary. I don't need to do anything. It's automatically mine. So I'm not going to hire a lawyer. I just know that it's mine. And the 9 months passes and they never file that affidavit. Well, they've lost it now. So I can't tell you how many people with joint property with rights of survivorship just go, okay, oh, great, I'm on the deed. It's joint. The house is now mine. I don't have to do anything. And it's years before they end up doing anything about it. So the other issue here is you never want to put minor beneficiaries on anything, much less a deed. Definitely not a deed, but not even on a bank account or life insurance or retirement account. You never want to put a minor on any of these things, because minors cannot inherit or own property by themselves until they're 18. So that means an adult has to manage it for them. And that adult has to be appointed by the court through what's called a conservatorship process. And if any of you followed the Britney Spears saga, I know she was an adult at the time, but it's the same process, that you've got an adult that gets appointed through the court system. The court micromanages everything. The law says that none of the money or the assets can be spent on the minor, and the minor just gets it all at 18. If money does need to be spent on the minor, you have to get court permission for every single penny spent. And if the court says no, then you're out of luck. You just can't use that on the minor. So if you find your way to our YouTube channel for my office, I've done a series of videos about why you never want to do this. If you have minors, you at a bare minimum always want to have at least a will that creates a trust later for your beneficiaries that are minors, or you want to go ahead and create that revocable trust now so that it's already set up for them. Okay. The reason I bring this up here is minors, if someone were to list a minor as a beneficiary on a deed, the law does not address who or how that minor claims this property. It takes oftentimes more than 9 months to get a conservatorship in place. It definitely takes more than a few months, and that's if you start right away. So the current law, under my interpretation, is a minor cannot claim any property without a conservator. So if you put a minor on here, you have to first get a conservator. If you can't get the conservator within 9 months, the minor loses the property. So it's a really, really, really big deal if that's who you want to benefit from you. So don't ever put minors on these. I already mentioned the opportunity for fraud and abuse. Y'all probably can't imagine some of the stories I've seen in my practice. I'm older than I look. I probably should have started with that. I've been doing this close to 14 years. So cover up my gray so that nobody really knows. But so I've seen a lot of things and a lot of really sad stories. And again, I mentioned this already. If your beneficiary dies before the owner, which again, we don't have a crystal ball, and you can go with statistics and all that, but we really just don't know. The beneficiary deed is not going to allow you to plan for contingencies if your beneficiary dies before you. So life estate deeds. So life estate deeds have been around a long time. I think I've probably done one of these where I thought it was a good idea. There's very few situations where I recommend this. Again, this is what a life estate deed is, where you change your deed to keep ownership of the deed during your lifetime, but you deed away what's called the remainder interest, meaning you deed away who gets the property after your death. So you keep a life ownership of the deed and you're giving away the remainder interest. The reason this is different than beneficiary deeds is because the remainder owner actually is considered as owning a piece of value of that property right away. So if you add a remainder owner on your deed, yes, if that person outlives you, you've avoided probate for passing it on to that person. But during your lifetime, you don't own it completely anymore. It's just similar to what I was saying with joint property. If you can't sell it, you can't refinance it. It's considered a transfer. There may be transfer tax. If you have a lender, they potentially could accelerate the loan. So you have all those same things. You also lose a portion of the step up in basis, depending on the value of the gift. And this is also the same for joint deeds. Depending on the value of the gift, if it's more than $18,000 in value, you have to do a gift tax return to the IRS to let them know that you made the gift. So I failed to mention that before with the joint deeds, but the other sort of new, I don't know how long, but interesting thing that I've learned recently is it does not protect your house against Medicaid recovery. So life estate deeds, even if you're doing that to get that out of your estate, so it's not in your estate when you pass, so Medicaid can't come after it. Well, Georgia Medicaid actually says they can. So I'm dealing with that for the client right now. Again, you don't get to plan for those contingencies if your remainder owner passes away. The other thing is, if your remainder owner passes away, they own that interest. That remainder interest is going to pass under their estate to who they want it to go to. Okay, so you can leave your remainder interest to your children, your new spouse, your stepchildren, your grandkids, whoever. So now you're going to end up owning your property with someone else that maybe you didn't mean to own it with. So again, very, very few situations where I would recommend this. Life estate deeds, I don't help people do the joint ownership deeds unless they're buying it together, of course. And the beneficiary deeds, the only time that I would help someone do that is if someone had capacity but had a diagnosis or that their life expectancy was not very long. I don't ever want to do anything on deathbed. I will if the situation requires. Anytime you're assigning things like this when someone's passing away or shortly within that time, you're setting that up to be challenged potentially. Not saying that people would win, but people use that as an opportunity to challenge. So I would do that if they if it looked like it was going to be really close in time. But again, we never have a crystal ball. So the last thing I want to go over, and I know I'm running out of time, and I'm sorry, I told you I could talk about this stuff forever. Revocable living trust. So this is the only way that I think you should responsibly pass real estate to loved ones in the event you're deceased responsibly. So what it is in addition, you always want to have a will, but in addition to your will, you create a separate document called a revocable living trust. It sounds like what it is. It's completely revocable. So it behaves just like a will during your lifetime. You can change it at any time. You can change your beneficiaries at any time in there. But think of it as a contract where it's an extension of you on paper. It has your social security number. It's not its own entity. When you deed your property to it, it's not a transfer. You still own it. Nothing changes about how you use it during your lifetime. Your lender doesn't care. It doesn't force an acceleration of your loan, nothing like that. So it solves all those issues. But not the biggest thing, but one of the bigger things is you get to plan for all sorts of contingencies. So in that document, you can say, this person will inherit from me if I pass away, but if they're not living, then it goes to this person. And if they're not living, then it goes to this person. So you can just set it and forget it, and you don't have to worry about updating it later. So I know I kind of went through that really fast. And Matt, you can certainly share these slides with everybody. There's nothing bad in here that you can't have. Feel free to email this to everybody. But I want to open it up for questions. I know that was a lot.
Yeah, no, absolutely. Thank you, Amanda, for running through that. It was very detailed. I'm always amazed at investors who will spend hundreds of thousands of dollars on an investment property and then go cheap on something like LLC planning or organizational documents and things like that. So, Chris, do you have any comments or questions you'd like to ask?
I mean, I like the advantage. We have quite a few clients, and I'm involved in a trust as well, where you can take care of like a disabled loved one or something, and have an administrator manage the account for that individual as they're living through life. And like you have a dependent child that's disabled or something like that, so you can use trust. It's a very valuable tool to establish a way for them to obtain and keep the assets, but someone else manage those and pass that income on to them. So I find that very valuable because we use a trust for my disabled brother and my mother and father's estate. So that's a beautiful tool for that. And I also like to keep it simple with LLCs. I don't, I think you need to separate your liabilities personally from your investment properties, and your investment properties liabilities from you personally. So I'm a big fan of using LLCs for that as well. So entities are a very important business strategy for managing your assets.
Yeah, absolutely. Absolutely.
Well, great. Well, I don't think I see any questions in the chat, but I think we covered. I think you covered a lot of great information for investors, and certainly my advice is always, as you're, for the new investors out there, as you're thinking, as you're planning, start talking to professionals early on. I was telling Amanda before we got on, a lot of times people come to us after a series of bad decisions, and we may not be able to unwind those mistakes for them. But talking to professionals in advance can really save you a lot of time and money if you do it right. And certainly when it comes to probate and estate planning, that's your family has enough going on that you don't want them to have even more headaches on top of this. I worked with a client. She did get her property foreclosed on during probate. She was trying to settle her mother's estate and worked with one of those big box attorneys, and it was after COVID and the courts were backlogged, and she thought everything was okay, and then found out 2 days later it had been auctioned off. So, there is a lot that can go wrong during the probate process. That's really challenging for a lot of people. Talking to somebody like Amanda can really, really help you there. So,
Yeah.
And also establishing those operating agreements for those LLCs, for contingencies, for in case you pass away, those signature rights for the checkbook control, management decisions, things like that are very key in that as well. And also the ascension of ownership. So that planning all that out inside that operating agreement is a key to handing those assets over to the next generation.
right, right,
Yeah,
absolutely.
absolutely. I've seen lots, well, not lots, but I've seen some folks where someone was in business with their friend or whoever, and then one of them passes away, and now the friend is stuck in business with the person's spouse that they didn't intend to be in business with. So, you got to plan all of that out, and it's such a great gift to your family. It benefits you, of course, and it gives you peace of mind, but it's really for them. It's such a great gift for them to have it all in order and make it as easy as possible.
Right, right. Well, great. Well, Amanda, what's the best way for folks to get in touch with you?
Oh, great question. So does everyone have access to the PowerPoint? So my information is on the PowerPoint, or
Yes, I will. Yeah, I'll post more of that information out there on the social media channels where we are. But I
yeah.
assume they can just go to your website and. Okay,
Yeah,
awesome.
so it's the Georgia Wills Trust and Probate Firm, and there's lots of firms out there now with similar names. And so what you want to do is go to our website is www.gawtpfirm.com. So that's GA stands for Georgia, W for Wills, T for Trust, P for Probate, Firm, FIRM.com. That's going to get you to all of our information. And our number is 770-795-4992. Just give us a call or shoot me an email. My email's on the PowerPoint if anyone wants to reach out to Matt to get that.
Okay. All right. Well, again, thank you guys for joining us for the Atlanta Landlord Luncheon. As a reminder, we meet every month. Happy to talk with you about property management. If you have whether it's your first rental property or a portfolio, we'd love to speak with you and talk about how we can protect your asset and make sure it is performing. Chip, you got any final comments?
You got to unmute. There it is. All right. So hey, yeah. So make sure you come to join us live on December 15th. And I don't know if Ted's going to be here live or if he's going to do it from his home office or wherever. But there'll be other people here that you can network with. So it's a great time to network with other real estate investors, especially landlords.
All right.
Thanks, everyone.
All right. Thank you.
Everybody have a great Thanksgiving.
We will see y'all next time.
Thanksgiving.
Great. Thank you, guys.